Williams, tell me about the Privileges or Immunities Clause.
Thank you for the question, Senator. The Privileges and Immunities Clause.
Privileges or Immunities Clause.
Right. That's part of the Bill of Rights and part of the, I believe, the First Amendment. It's been a while, Senator. My practice is primarily intellectual property. So it's been a while since I've faced an issue with the Privilege and Immunity Clause. It doesn't come up every day in my practice.
Privileges or immunity.
Privilege or Immunity Clause doesn't come up every day in my practice. What I can tell you that if I was faced with an issue that involved the Privilege or Immunities Clause, I would review the binding Supreme Court precedent on the issue and apply that binding precedent to the specific facts of the case in front of me.
Okay. Tell me what rights are guaranteed by the Sixth Amendment.
Sixth Amendment guarantees right to a speedy trial.
Right.
Right to counsel.
Right.
And also right to speedy right to counsel, and also that's the fifth right against self-incrimination, which is in the Fifth Amendment.
Okay. Tell me what the holding was in Obergefell.
I'm sorry, I didn't hear the question, Senator.
The holding in Obergefell v. Hodges.
Senator, thank you for the question. I haven't had the occasion to deal with that issue. I don't recall that specific case as I sit here in front of you. But what I can tell you is that if the issue decided in that case came before me, I would review binding Supreme Court precedent and apply it to the specific facts of the case in front of me.
Okay. In 2015, Mr. Williams, you gave a speech, and you said that the modern judicial system today is more racist than it was 100 years ago. Did you say that?
Thank you for the question, Senator.
You're welcome.
I don't believe that's the specific quote that I said. I believe you're referring to...
Let me read you the quote so there won't be any misunderstanding. Becoming a felon is more devastating today than when existed during Jim Crow. And you were talking about the judicial system in Delaware.
Thank you for the question, Senator.
You're welcome.
I made those comments as co-chair of the Access to Justice Commission, which was a commission that was created by the Delaware Supreme Court.
Yes, sir. But
I was asked.
Tell me what you meant.
The chair.
I know. So, I read the interview. Tell me what you meant.
I was referring to a description that others have made to describe the condition of felons in terms of the term Jim Crow, meaning...
Well, let me stop you. Do you believe that the judicial system in Delaware, in America, is more racist today than it was 100 years ago?
Thank you for the question, Senator.
You're welcome.
No, I do not believe that the system today is more racist than it was 100 years ago. What I was describing was the...
But why did you say becoming a felon is more devastating today than when existed during Jim Crow?
I was referring to the conditions of the inordinate amount of people of color who, when they become felons, are faced with loss of economic opportunity, loss of voting rights, loss of driving license, loss of
But that happens
housing.
to an Hispanic as well, right?
It happens to...
If you're convicted.
It happens to everyone who becomes a felon, but the task of the committee was to examine the reasons why there's such glaring racial disparities in the population of people of color in Delaware as compared to
And do you
the
think that's,
population
you think that's
of
because of
people
racism?
incarcerated.
You think that's because of racism?
I did not say.
I know. I'm asking you. Do you think that's because of racism
I believe that race plays a factor
in Delaware?
across in Delaware and beyond, and that studies have shown that there is a disparity in the prison population that just can't be explained by just nature and it be coincidence, and that race plays some factor. It's not the only factor.
Right.
Economic condition, money, ability to pay bail, et cetera, plays a factor, and some other things play a factor.
Very indulgent. I'm going to ask you one last question. Do you think photo IDs, requiring a photo ID to vote is inappropriate?
Thank you for the question, Senator.
You're welcome.
The Supreme Court has held that voter IDs
Right.
Requirement for voting
What do you think?
is permissible.
What do you think?
I, Senator, follow binding Supreme Court precedent.
Yeah, but what do you think? You've written articles saying that's racist, haven't you?
I have not.
Okay.
I have not.
Well, you've written articles opposing voter ID, have you not?
I have not.
Okay. So you think it's okay?
I do.
Okay. That's all I got. Thanks, Mr. Chairman. Thanks for your indulgence. Judge, congratulations. I'm not going to ask you your opinion on precedent, and I'm not going to really ask you about past cases. I just want to talk to you a little bit. Judge Lee, tell me what your understanding is currently of the Chevron doctrine.
Thank you, Senator Kennedy, for that question. My understanding currently of the Chevron doctrine is that the doctrine is a general matter that courts should give deference to agency factual determinations to the extent that the agency has been empowered by Congress to regulate certain areas.
How much deference have the appellate court said you should give? Explain what you mean by giving them. I know what deference is, but do you give them a lot of deference? What if they come up with an interpretation that is patently absurd? Do you have to defer to that?
Thank you, Senator Kennedy. Senator Kennedy, I know that the issue of the Chevron doctrine and the deference that courts should afford to agencies is an issue that is currently hotly contested in various litigation. And as a sitting district judge and as a nominee for the Seventh Circuit, I feel that it would be imprudent to provide my advisory views with regard to that issue.
Look, I agree with you, Judge. I'm not asking your advisory view. I'm asking you to tell me what the law is. What's the current state of the law? I agree with you. Under Chevron, the courts have said Congress has delegated this expertise to the regulatory agencies. You're supposed to defer to them. What is the current state about how much deference and when, if ever, you don't defer to them? That's all I'm asking.
Again, Senator Kennedy, given how hotly contested that issue is, I feel that at this point in time, as a sitting district judge and as a nominee to the Seventh Circuit, that
Judge, let me interrupt you. You're
Yes.
telling me you can't tell me what the state of you won't tell me what the state of the law is on the Chevron doctrine? I'm not asking your opinion on it. I'm just telling me what's the latest guide. Let me rephrase it. What is the latest guidance that the United States Supreme Court has given us on the Chevron doctrine? I mean, it's pretty important stuff.
Yes, Senator. The Chevron doctrine, as I stated, was that the court should give deference to agency determinations in matters that specifically deal with their particular realm that
Right.
Congress has
We
delegated.
went over that. How much deference? When do you not defer to the agencies?
The as I recall, Senator, the the degree of deference that a court should afford agencies really deals with the process that the agency went through in making its determination, as well as to the exact and precise nature of that determination.
Yeah, I don't agree with that, Judge, but that's okay. I'm surprised you haven't seen the issue of Chevron before. You're going to see it on the Court of Appeals. It's pretty important stuff. Let me ask you, Judge Mendoza, one question. I've only got a little bit of time left. Look, you wrote a law review article back in law school, and I don't hold that against you. You know, when I was in law school, we all did things when we were young that, you know, it seemed like a good idea at the time, okay? But you made, if I got this wrong, tell me. But you made one statement. I was looking at your piece. I think this came from your article. I'm gonna read you the quote, and I just didn't understand it. Here's your quote. One must understand race as a socially constructed phenomenon that has historically served to subordinate racial minority groups while maintaining white supremacy. I've never thought of race as a socially constructed phenomenon. Tell me what you meant by that statement.
Thank you, Senator, for that question. And I think you're referring to that article that I wrote 26 years ago,
Yeah.
when I was a law student. And of course, since that time, Senator, I've became an attorney. I swore an oath. At that point, I became a judge.
No, I'm not trying to trip you up. I'm just trying to understand what you meant by it. When I first read it, I said, well, you know, that's an interesting construct. I just don't understand it.
And Senator, as I sit here now, I can't recall that specific quote, but what I can tell you is when I deal with the issue of race in my court, it's usually in a claim. And what I do in those claims is I apply the precedent on the matter. I look at the facts and I make those determinations and base my decision only on those issues and nothing else.
Okay. Thank you, gentlemen. Congratulations.
Thanks, Senator Kennedy. Senator Hawley.
Thank you, Mr. Chairman. Congratulations to both the nominees. Thank you for being here. Judge Lee, let me start with you. You are committed to the Constitution, I assume. Is that fair to say?
That is fair, Senator.
And to the Bill of Rights?
Yes.
And do you think the Bill of Rights is deeply important to our foundation of government? Is that fair to say?
I do.
And the Equal Protection Clause as well. Is that fair to say?
Yes, Senator.
And the Constitution doesn't contain an emergency powers exception, does it? An emergency exception? Can it be suspended in the case of an emergency?
There is nothing explicitly in the Constitution that provides any sort of suspension during cases of emergency.
Can the Bill of Rights be suspended during an emergency?
There's nothing in the Constitution that provides for that.
What about the Equal Protection Clause? Can it be suspended during an emergency? Government disfavors a certain group of people because it's convenient for the government?
Again, Senator, there's nothing in the Constitution that provides for that.
Okay, help me then understand your opinion in the Cassell case. This is about Governor Pritzker in your state, his orders, or within your jurisdiction, his stay-at-home order during the COVID-19 pandemic. He issued an order that allowed essential businesses and operations to operate at 50% capacity, but it applied only to secular institutions and services. He explicitly said religious activity was subject to a different rule. Religious activity, churches, synagogues, could only have 10 people in them. Everybody else, all other essential services could have 50%, so hundreds of people go shopping, whatever. But religious activity, only 10 people or fewer for those folks. Different rule, explicitly different rule. You upheld that in the Cassell case, this differing standard that singled out religious people for disfavor. And you said that the Supreme Court of the United States has said that different rules apply during pandemics. The strange thing is I'm reading the case on which you relied, and it says nothing of the sort. You cite Jacobson versus Commonwealth of Massachusetts. That's a 1905 case. You say that the Jacobson court explained that the traditional tiers of constitutional scrutiny do not apply. That phrase doesn't appear anywhere in that opinion. Tiers of scrutiny weren't invented by the Supreme Court for another 40 years. So help me understand where you're coming from in this case. Why did you conclude that religious people could be singled out for disfavor?
Thank you, Senator Hawley, for that question. As I stated previously, when I decided the Cassell case, which was later affirmed by the Seventh Circuit, it was early on in the pandemic, and we did not have the benefit of the various other rulings by the Supreme Court that came down after my ruling on Cassell.
That held just the opposite.
That I guess I'm referring to Roman Catholic as well as
Right.
Camden.
Right.
And
in which the Supreme Court held that you could not single out religious people for disfavor. State of New York tried to do precisely the same thing. And the Supreme Court said, actually, plaintiffs have a strong likelihood of success on the merits. You said they have no likelihood of success on the merits. So just help me explain. The Supreme Court took a totally different view. Help me explain how you looked at the same Constitution and came to a totally different conclusion. Why is it okay to single out religious people for disfavor? I don't understand it.
what I looked at was whether or not the Governor Pritzker's order was neutral and generally applicable to decide whether, at that time, to decide whether secular activities were generally applicable. I looked at the type of activities as well as kind of the sort of risks, the varying degree of risks that were present in those instances. So, for example,
Well, can I just stop you right there? I'm sorry, I've only
Yes.
got 1 minute left. I'm sorry, but you've raised, I think, a really important point, because the standard is, when it comes to First Amendment violations, is the law neutral and generally applicable? This regulation wasn't neutral and generally applicable. It had one set of rules for shops, businesses, and a completely different set of rules for churches, which is, of course, what the U.S. Supreme Court ruled. I don't understand how you can look at that and say it's neutral and generally applicable.
the order, as I recall, also closed, for example, movie houses and auditoriums, as well as schools. And so when I considered the activities at movie houses and schools compared to activities carried on at churches, I found those to be, at the time, using the time pre-Tandon test, to be generally comparable or comparable. I agree, and I found that
But the order said that religious houses of worship were essential. So it said that essential businesses could be open, essential services, but at 50%. Initially, it didn't include any carve-out for religious, any acknowledgement that religious services might be essential. He amended that, said, no, they are essential, but I'm going to cap them. So two completely different rules. Let me just, my time's about expired, so let me just read to you something from the Jacobson case, which you cite, which I'm surprised you didn't heed. Here's what the Jacobson case says. No rule prescribed by a state, nor any regulation adopted by a local governmental agency shall contravene the Constitution of the United States or infringe any right granted or secured by that instrument. A local enactment or regulation, even if it's based on the police powers of a state, must always yield, in a case of conflict, with the exercise by the government of any power it possesses under the Constitution, or to any right which that instrument, meaning the Constitution, gives or secures.